The Office of the Ombudsman has jurisdiction over all elective and appointive officials of the government, its subdivisions, instrumentalities, and agencies. This includes members of the cabinet, local governments, government-owned or controlled corporations, and their subsidiaries. The Office of the Ombudsman can subject these officials to its disciplinary authority, except for members of Congress, the judiciary, and officials removable only by impeachment. However, if warranted, the Office of the Ombudsman may investigate serious misconduct in office allegedly committed by officials removable only by impeachment for the purpose of filing a verified complaint for impeachment. The aforementioned civil servants under the jurisdiction of the Ombudsman could be charged both criminally and administratively in their office. This article will focus on the procedure for handling an administrative case. An administrative case may be initiated by a written complaint under oath accompanied by affidavits of witnesses and other evidence in support of the charge. Such a complaint shall be accompanied by a certificate of non-forum shopping duly subscribed and sworn to by the complainant or his counsel. Additionally, an administrative proceeding may be ordered by the Ombudsman or the respective Deputy Ombudsman on his initiative or on the basis of a complaint originally filed as a criminal action or a grievance complaint or request for assistance. Upon receipt of the complaint, the same shall be evaluated to determine whether it may be dismissed outright or treated as a grievance or request for assistance. If the complaint is docketed as an administrative case, the respondent shall be furnished with a copy of the affidavits and other evidence submitted by the complainant and shall be ordered to file his counter-affidavits and other evidence in support of his defense within 10 days from receipt thereof. If the hearing officer finds no sufficient cause to warrant further proceedings on the basis of the affidavits and other evidence submitted by the parties, the complaint may be dismissed. Otherwise, he shall issue an order, or orders, for any of the following purposes. To direct the parties to file, within 10 days from receipt of the order, their respective verified position papers. The position papers shall contain only those charges, defenses, and other claims contained in the affidavits and pleadings filed by the parties. Any additional relevant affidavits and/or documentary evidence may be attached by the parties to their position papers. On the basis of the position papers, affidavits, and other pleadings filed, the hearing officer may consider the case submitted for resolution. If the hearing officer decides not to consider the case submitted for resolution after the filing of the position papers, affidavits, and pleadings, to conduct a clarificatory hearing regarding facts material to the case as appearing in the respective position papers, affidavits, and pleadings filed by the parties. At this stage, he may, at his discretion and for the purpose of determining whether there is a need for a formal trial or hearing, ask clarificatory questions to further elicit facts or information. Summarily, the Office of the Ombudsman covers the investigation and prosecution of administrative and criminal cases against public officials and employees, as well as complaints against private individuals involved in graft and corrupt practices. The order outlines the procedure for filing complaints, conducting investigations, and imposing penalties on violators. It also establishes the roles and responsibilities of the different units within the Office of the Ombudsman in carrying out their mandate to promote accountability and integrity in public service. For more information and update on concerns and issues with impact to education and civil service, please like and follow this page and channel.